Hi everyone, this is Griffin Bridgers. Welcome back to A Better Approach to Estate Plan Funding. In this fifth installment, we're going to look at the theory behind how a revocable trust alone is not enough. But while I say theory, there's also a lot of practical, but the practical would take 30 seconds to cover, so most of this presentation is going to be about the theory and the why behind the practical elements of this, just to aid your understanding and build a better foundation for what's to come. Now, fair warning, today isn't so much about actual methodology of funding the trust itself. It's about creating backup systems and redundancy for the funding of the trust as not necessarily a prerequisite to the actual work of doing so, but more just so that you have an interconnected web of adequate legal documents and legal protection. So before we get started, I want to remind you again, this course is intended for educational purposes only and is not intended to substitute for legal or tax advice. So with that being said, jumping back to our broad concept we've been looking at so far, where everyone has two parallel estate plans. First, the non-probate assets. Second, in priority, the probate assets. And what we've been exploring is ways we can have an omnibus set of documents that affects both buckets, so that we don't have to go through, especially on the non-probate side, and change the disposition asset by asset, as opposed to on the probate side where a will or intestacy laws can cover everything. So in the last presentation in this series, we introduced the revocable trust with the theory that yes, that might be the way we can combine these two buckets. But today's broad question is whether or not the revocable trust is the only document we need. And as we'll find out, it's a start, but it needs to be backed up by a couple key documents. So I'm going to give a quick personal example where in my household we're going through that seemingly never-ending effort to minimize and downsize what we own. So there's been a couple major purchases that we've recently made. One for my business personally, a scanner and printer to digitize a lot of the work and personal paper files that I have to free up office space. And then also on the personal side, a DVD binder to hold discs so that we can get rid of the cases and free up shelf space, especially for DVDs that are rarely watched in the world of streaming, but that we don't necessarily want to get rid of yet. Now, these are both kind of receptacles that are similar to a revocable trust. And I saw as I was going through this that yes, I can have these, but unless I'm willing to put in the work to fill the receptacles, they're not going to do me any good. So that's kind of a good analogy for funding the revocable trust. But there's another element to this, especially on the printer side, before I even jump into the funding or the use of it, is that the printer would be useless if, for example, I didn't have a power cord or toner or an internet connection or even some sort of place to store the scanned documents in the cloud or locally on a computer or server. So we have all these ties that have to be put in place before we can even start funding a revocable trust. So the question is, how can we create these equivalents of like a power cord or internet or whatever for the revocable trust? And that kind of starts with our general common issue today, is that revocable trust documents alone are not enough. They have to be accompanied at a minimum by 1, a pour-over will, and 2, a durable power of attorney. So I'm going to cover a little bit more about what these documents do, but they both have the effect of creating a backstop for funding purposes. In one case, for probate assets, and in the other case, for both buckets, the non-probate and probate, but it's going to largely depend on the powers that are created within each document. So with that, as I alluded to, and as you may have picked up, this pour-over will and durable power of attorney can each be thought of as playing the role of having maybe part power cord, part internet. And we're going to cover why these documents are important. So now that you know the practical, we're going to dive into some of the theory behind it, mainly because when you do this, you're going to have questions from clients too, like why do we need to get these extra documents? Why isn't the revocable trust enough? And we're going to look at kind of the emergency situations that are a lot easier to cover up front once than it is to put them off and deal with trying to scramble to get these things in place later. So the general issue and why we have these two documents that need to accompany a revocable trust is because, despite our best intentions, we do not always get around to fully funding our revocable trust. So again, there's different ways to fund a revocable trust. We're going to get into those, so please don't worry. But for the time being, the question is not around the substance of funding. It's more around who has the authority to fund our revocable trust. And to understand that, what we need to understand is the fact that when we create a revocable trust, that becomes the document that has all of the instructions for how our property is to be distributed at the time of our death. So as we talked about early in all the preliminary installments of this series, with non-probate transfers, if you name an individual, that is going to override the revocable trust. But we also have to look at the probate bucket. So obviously we want to avoid probate, which we can do through proper funding, either putting assets in or naming the trust as beneficiary, as we will later discuss. But the problem is that applies to non-probate. How do we deal with probate? And this is where a pour-over will comes in for assets that we just don't get around to putting into the trust that are included in the probate bucket. This can include pretty high-value illiquid assets, things like real estate, business interests or other interest in entities or closely held businesses and private investments, things like that. So if you own an interest in any form of partnership or LLC or corporation that isn't publicly traded, chances are it's going to end up in that probate bucket. So with that, what we have is a pour-over will that has the effect of saying that anything in the probate estate that we own at our death that's not already in the revocable trust, or even that our estate acquires rights to after our death, will ultimately go to our revocable trust. And obviously this creates the need for probate potentially if you're over probate limitations or small estate limitations in various states. But that aside, the privacy element is preserved because now there's a trust and not necessarily individuals who creditors and other interested parties can track down to find and bother. But with that, if we don't have a pour-over will, the outcome will be that any probate property we haven't put into our trust will be subject to intestacy and will never ever make it into the trust. Will be reliant on the intestacy laws, which is a very bad outcome depending on your family situation. It's not something I would ever recommend. And really, the pour-over will isn't just about the substance of getting property over to the trust. It's more about the naming of an executor or personal representative, both meaning the same thing but interchangeable terms depending on the state you're in, and that executor or personal representative has the power to collect, marshal, inventory, and then ultimately get your property over into the revocable trust, at which time the trustee of the revocable trust will take over. Now, way back in part 2, we talked about how sometimes the trustee who takes over for the settlor after the settlor's death kind of can sometimes play a pseudo-executor or personal representative role, but this is one role that trustee cannot play. It is completely separate in terms of the authority of the trustee versus the authority of the executor or personal representative. You've got to have a separate pour-over will that nominates somebody to fill that role. And it could be the same person in both roles, but you have to respect the fact that they are different roles, and one document can't create dual authority between both. Now, with that being said, we talked about what happens if we never get around to funding and we die and run out of time to do so. But a lot of people assume, one, they're going to live forever, which isn't a bad assumption. That's a belief I think you would find common among a lot of clients. But we also have the issue that what we can't predict is disability or incapacity. And if you become disabled or incapacitated, guess what? You may lose the ability to fund the revocable trust, because you will no longer have the capacity to enter into contracts and transfer agreements or beneficiary designation changes or whatever's needed to fund the revocable trust. And in the worst case, a conservator or a guardian of property, both being interchangeable terms like executor and personal representative, one of those fiduciaries may be appointed by the court, which leads to a court record and fiduciary jurisdiction over an individual's assets if that individual has been deemed disabled or incapacitated. Now, assets that are already in the revocable trust at the time of that appointment will escape that court intervention, but there's that risk that maybe assets put in before court intervention may not have been validly transferred. And there's also the issue that going forward, we no longer have the personal ability to put property into our revocable trust. And with that, since the revocable trust is separate from our individual assets, the court has no jurisdiction over it. Instead, it's a private agreement between the settlor and the trustee, who then can administer property in the trust for the benefit of a settlor who is disabled or incapacitated, without the conservator or guardian necessarily having any or even full jurisdiction over that process. But to get there, what I'm angling towards inartfully and indirectly is that we need somebody who has legally enforceable authority to get property into our revocable trust. And that's where a durable power of attorney comes in. This allows us to name an agent or attorney in fact, again, interchangeable terms, who has various powers which include, but are not limited to, the funding of our revocable trust. Now, it's important to have a durable power of attorney for one's individually owned assets to begin with, both probate and non-probate assets. However, there's a lot of form documents out there, and those form documents do not always give the agent the power to fund a revocable trust. And even in form documents that have that authority, it may be too generic to be enforceable independent of the conservator's authority. In other words, just saying, you can put property into any revocable trust I have may not be effective and may require the consent of a conservator, whereas if you're more specific about, I have this trust with this name and date, and I want to put property into it or give my agent the authority to do so in these ways, that's going to be a lot more enforceable, maybe independent of the conservator's authority. So there's a couple ways we can get there. One, if you don't want to gum up the works with multiple documents, you can add language to a broader durable power of attorney that creates that authority. Or two, you can have a separate standalone durable power of attorney that creates that authority. Now, there's no right or wrong as to comparing the two options, but the one issue I'll kind of distinguish between them on is that we have this broader question of whether the power of attorney should be immediately effective, in other words, not dependent on disability or incapacity, or if it should be a springing power of attorney that springs into effect if we become disabled or incapacitated. So, for funding the revocable trust, it often becomes a little bit easier and less prone to abuse, perhaps, to have an immediately effective power, whereas, especially for non-family members or non-spouses as backup agents, under a general durable power of attorney, it may be preferable in some cases for that to be springing. So, for example, if you wanted that immediately effective authority it may be helpful to have a standalone durable power of attorney for funding if you want your general durable power of attorney to be springing. Or on the other side, you could bifurcate and have provisions in the broader omnibus general durable power of attorney that says all provisions except the funding of the revocable trust are going to be springing. Like I said, no preference either way. It's just something you need to be sensitive to. Now, just having these documents isn't the end of the road. One of the biggest mistakes I see, as I alluded to last time, is an erroneous reference to the trust. And remember, there's really two elements that have to be identified in the name of the trust. You have to have at least the name of the trust, and two, what's often missed is the date of creation. That is how the revocable trust has to be referred to. And depending on the state, it also helps to identify the trustee, not necessarily always by identity, but by role. So you could have name of trust executed on such date, or you could have trustee of name of trust executed on such date. Either should suffice. But this identification holds true for both the pour-over will and the durable power of attorney. Now, I referenced earlier that we kind of start with a revocable trust, and we have these two documents that tack onto it. And there's an additional requirement that's often missed, and we get way too much into legal theory here, so if you nerd out on that type of stuff, I'm going to cover this real quick, but the general principle is going to be that the revocable trust ideally should exist at the time that the pour-over will and durable power of attorney that creates funding authority are each executed. And that's because of a doctrine known as incorporation by reference that says, especially for a will, you can reference another document in your will with some exceptions, as long as that document exists at the time that you create the will with the reference. So if you execute a will first and then execute a revocable trust after, you run the risk that there's not effective incorporation by reference, and thus you run the risk that there wouldn't be an effective pour-over. Now, that doesn't apply to all documents. There are some documents you can create after the fact, like tangible personal property memoranda or statements of intent with regard to gifts and advances that may shoehorn in, but those shoehorn in better with a revocable trust to begin with than with a will, because of this theory of incorporation by reference, which can vary by state, but generally under common law requires a document that's referenced to be in existence at the time that the referring document is executed. Now, moving on beyond that, as I've alluded to, and as I know a lot of you are waiting for, we'll tackle in this series some of the broader questions of methods of funding. For example, should we title assets, especially taxable assets, in the name of the trust now, or use a non-probate transfer that takes effect at our death, kind of like a POD or TOD designation, or a beneficiary deed or ladybird deed, depending on the state, where we can add property to the trust effective at our death. Now, titling is going to count there, but the central consideration that I'm going to ask you to keep in the back of your mind that's often glossed over is that beneficiary designations won't help to limit the scope of court or conservator authority over non-probate assets. Now, there's some non-probate assets that have to stay in your individual name during life. Things like qualified plans, IRAs, sometimes annuities, depending on the setup, and even life insurance as well, depending on level of access desired to internal cash value buildup. So with that being said, obviously those have to have beneficiary designations that take effect at death and will be possibly subject to a conservator's authority during life. But if conservatorship limitation planning is the goal, that creates a nod towards putting other assets like bank accounts, securities, closely held business interests, and real estate into the revocable trust itself sooner rather than later, as opposed to setting those up to have transfers on death. And with this, we'll have to consider things like whether the agent with the authority to fund the trust has additional authority over all non-probate assets, like changing beneficiary designations to the trust itself, and a hot power amending the trust on our behalf and or removing and replacing trustees. All those are kind of finite decisions that are often better left to an attorney and are helpful to think of as options, but they're options that could be subject to abuse and in a lot of states would require a specific designation of that authority, possibly with an initial, without a general grant of authority creating that type of outcome. So all that being said, key takeaways for today are that 1, a written trust agreement of a revocable trust is not enough by itself. It should always be accompanied by at least 2 other documents, one being a pour-over will that's validly executed, another point that's important to note, and that pour-over will needs to appoint an executor or personal representative with the authority to transfer probate property to the trust at the settlor's death. Another important document takes effect upon disability or incapacity. That's a durable power of attorney, with either a standalone power of attorney for this function or specific custom drafted language for this function within a broader durable power of attorney. But either way, appointing an agent or attorney in fact who has the power to transfer both non-probate and probate property to the trust if we become disabled or incapacitated, or even under immediate authority that's not springing, i.e., not dependent on subsequent disability or incapacity. Remember that under the incorporation by reference theory, technically the revocable trust needs to be accurately identified in both of these documents and should exist before these documents are executed. Now, that doesn't mean you can't execute everything in one setting, but technically if you're trying to be hyper conservative, if you're doing an execution of all documents, execution of the trust should come before execution of the will and durable power of attorney. Now, what I didn't mention in the pour-over will, because we're kind of getting into other territory here, is that the pour-over will should have what's known as a residuary clause, which, as I talked about in the first installment in this series, is the backstop that catches all of the probate property not specifically disposed of. And that residuary clause should say that the residuary estate passes to the revocable trust that's identified at least by name and date of creation, either by name generally or by trustee of name of trust and date generally as well. Same thing applies to the durable power of attorney, identifying the trust properly, but also giving the agent the express powers to transfer assets in various forms to the trust, which, as I mentioned, may involve some hot powers that you want to give some consideration to. Now, in this vein, online forms may not be sufficient to, 1, specifically identify and incorporate by reference the revocable trust in either document, or 2, to give the agent the express authority to fund the trust, at least in the ways that the client may want it funded. So you can consider either a standalone durable power of attorney for funding or express authority that's custom drafted in a broader general financial power of attorney. Either is viable, but I want to keep in mind too that it may be better to have funding authority immediately effective and not necessarily springing, depending on the depth of authority that is granted to the agent. If you're giving them hot powers like amendment and beneficiary designation changes, you may want to consider a springing durable power of attorney for those types of hot powers, but general funding authority to transfer probate assets into the revocable trust may be good to have that be immediately effective when the power of attorney is executed. So that's it for today's presentation. As always, please reach out with questions, but coming up next in this series, we'll start to explore the differences between a joint revocable trust for spouses or partners versus individual revocable trusts, and dive into what is actually a hotly contested debate amongst practitioners depending on their background, what state they practice in, and what type of property is going into the trust. But thanks again for listening, and I look forward to seeing you in future installments of this series.